unusual case here, with the court appointing an additional liquidator in the case of Noel versus Noble Pina Capital LLP. A hotly contested matter, and you can see above that it was well represented by senior leading Chancery counsel. Indeed, the front row of the court was occupied by not less than 3 KCs. And, of course, the judge herself a KC as well. Now, this covers the subject that ultimately the background was a removal of a liquidator application. And yet, on an interim basis, an additional liquidator was appointed by the court in the form of Mr. Robert Horton on an interim basis. The point being made that there's going to be a period of time between the determination of the removal of the liquidator application and the position that was the case in December or November last year when all this kicked off. Interestingly enough, the court in this particular matter really did get its skates on. Normally, the concept of delay and so on is not uncommon in court proceedings, but in this particular case, the court really did move itself. And there were a couple of key issues in this case that the court had to consider. One was whether the applicant had standing, was able to effectively bring the application for the removal of liquidator, and the other was the matter of jurisdiction of the court to appoint an additional liquidator. There have been a number of cases in the past where the court has appointed a conflict liquidator, and that was considered in this particular case. On the point of insolvency, the court very rapidly determined that the applicant was entitled by a certain date to be considered, if nothing else, a contingent creditor, and therefore did have standing and the ability to bring the application. Ultimately, not uncommon in the case of removal of liquidator applications, the matter involved the question of allegations or dissatisfaction with the liquidator. As you can see above, the court made reference to the fact that there were some very serious allegations made against the current liquidator. As to matters of jurisdiction, the court said in its judgment the court did have jurisdiction to appoint an additional liquidator, and that such jurisdiction arose from Section 108 of the Insolvency Act 1986, as set out in the case of Clements versus Udall. The court went on to say that, in my judgment, in a case where a serious conflict has been raised, it is arguable that the current liquidator may be unable to carry out his functions. One of the issues that the court canvassed with counsel was the matter of what would happen if a liquidator had done something seriously wrong, like misappropriating company assets in their favour, and there's a removal of liquidator application that is in process, but there's the period of time between the issuing of the application and the hearing of the application. What happens in that period, and whether or not an interim liquidator should be appointed to safeguard the interests of creditors, and this was obviously critical to part of the issues that the court considered in relation to the matter of jurisdiction that the court inherently has over insolvency proceedings generally. The court particularly looked at the distinction between compulsory liquidations and voluntary liquidations, which in this particular case, this was a members' voluntary liquidation, and it said that the court did have jurisdiction, and accordingly, as a result, it appointed the additional liquidator. Questions, queries, concerned, give us a shout. We know insolvency inside out.